Hi, Alec from Proactive Accounting here again. Getting to talk to you today about wills and superannuation. Superannuation is one of my favourite subjects, and wills is something that's inevitable. Strangely enough, it's noted that 60% of people actually don't even have a will. And another statistic, and I'm not even sure what this number would be, but a lot of people don't realise that their superannuation does not form part of their estate. Now, superannuation is it's normally held in a structure which is a trust, and the trustee of that fund is the one that makes the decisions as to where those proceeds go. Now, you can nominate where you want it to go, and a lot of people, possibly through lack of knowledge, also through lazy advice, that would probably just get told, just direct it to your estate. Now, there's a lot of reasons why you shouldn't direct it towards your estate. Firstly, going back to the wills, where we have the statistic that most people don't have them anyway, but there's also another statistic that of wills that are that people make, 60% of those get challenged. And there's a pretty high success rate by the challenger in actually overturning those wills. So what do you have here? You're putting your superannuation into an area which it's not secure. It can be challenged. Another problem is, given that wills can be challenged, the administrator or executor of that will is going to be loath to pay out to the beneficiaries of, in your will, the proceeds, because if there is a challenge and it's successful and that person's paid the money out, he or she would become personally liable under that estate. So just think logically. If I'm executor of estate and the money's come in there, I am going to wait until that statutory period. Now, it varies from state to state between 6 months and 12 months. I would be, if I was running that estate myself, I would not be willing to take a chance on being personally liable myself. So I'm going to hang on to that money until that period where challenges can be made. Now, have a look at it from the family's point of view. Imagine if it's a breadwinner who's passed and there's, the family are wanting some money to survive, to pay the bills and all that. They're not going to have it for quite some time while that period of potential contesting takes place. So, not a good idea to put it to your estate. You can nominate in your will doc, in your superannuation. You can actually nominate who gets it, and you could say, "Pay this to my spouse," and it gets paid immediately. It doesn't go to the will; it gets paid out while the estate gets administered and all that, but the money goes straight through the super. The other thing you can do with estates is a thing called a testamentary trust. Now, the beauty of a testamentary trust is it has preferred tax status for minors. It's also a great tool for protecting money that's gone to an individual who may have some particular circumstances where they could be challenged. So it is protected if you take it from your will into a testamentary trust in favour of, who you want it to go to. It's a pretty basic strategy that just gets missed because I think people just aren't aware of it and nobody bothers to tell them. Even if you go to a lawyer, there's simple ways to put it to the estate so they can deal with everything in one place. So if you're not sure that you've got this right for yourself, we'd love to talk to you, because our opinion is estate planning is a lot more than just making a will. A bit of thought going into it can save you some really nasty kind of outcomes, which are easily avoidable. So here's the deal. You want to know more about it? Book a time to have a chat with me. I'd love to talk to you about it. As I say, it's one of my favourite subjects, and estate planning is really something where the difference between not putting some thought into it and putting some thought into it is significantly different. So, love to talk to you. book a time and yeah, we can have a chat. Thanks then, eh? Bye.